Let's face it, it hasn't been easy to pick up sides on the upcoming referendum. From all sides of the debate, it seems like we have political or even misinformation happening. And so I want to offer you some new perspectives on this upcoming voice referendum. In my previous video, I offered an unbiased opinion on 5 arguments for and 5 arguments against entrenching the voice in the Constitution. So today I want to dissect the proposal itself. What are the words actually saying? What's the proposal doing? What are the potential implications of having an entrenched constitutional voice? Hello everyone, my name is Renato Costa, this is Aussie Law, and today I'm offering an unbiased explanation of the Voice Referendum proposal and its constitutional implications. The question being posed in the referendum is this: a proposed law to alter the constitution to recognize the first peoples of Australia by establishing an Aboriginal and Strait Islanders voice. Do you approve this proposed alteration? Ultimately, we are dealing with a proposal to change the constitution that will recognize the Aboriginal and Torres Strait Islanders people as the first peoples of Australia. The voice, this body that is also part of the proposal, is the means by which that recognition will be materialized. The proposal is to recognize Aboriginal and Torres Strait Islander people as the first peoples of Australia, and the recognition will come by the establishment of an Aboriginal and Torres Strait Islander voice. In this respect, you may remember that in 1999, a referendum that most people remember as the Republic referendum also proposed the inclusion of a preamble to the Constitution. That preamble would recognize Aboriginal and Torres Strait Islanders as the nation's first people. Now, I have a particular view about the nature of that preamble, and you can check that in my video up here. So I think it is weird to add a preamble after the Constitution has been enacted. But this is not particularly relevant right now. What is relevant is that in the failed referendum of 1999, there was a clause saying that the recognition of Aboriginal and Torres Strait Islanders as the first peoples could not be used to inform the interpretation of the Constitution. And this is very important because no such provision exists in the current proposal. This means that in the new attempt to include in the Constitution a recognition of the first peoples of Australia, there's no limitation on what could be the constitutional implications of that recognition. And I think that's even more evident in the fact that this new proposal of constitutional amendment is creating a new chapter in the Constitution entitled Chapter 9, Recognition of Aboriginal and Torres Strait Islander Peoples. All in all, I have come to believe that there are profound implications coming from that recognition as an integral part of the structure of the Constitution. Indeed, recognizing who are these first peoples of Australia can influence on the whole concept of constituent power. It may affect the High Court's interpretation that the Constitution is the result of the Australian people uniting to form a federal Commonwealth. So look, ultimately this recognition may affect our understanding of federalism and even raise questions about the relationship between the people of the states, as it says in the preamble, and the first peoples in section 129. There are doubts of whether these may impact the democratic institutions that are implied from the expression directly chosen by the people in section 7 and 24. I mean, what people is it referring to? And here it is important to remember that the High Court of Australia derives implications from the constitutional texts all the time. And so even if the text itself at first glance has nothing to that effect, implications may still be drawn from it. The recognition of Aboriginal and Torres Strait Islanders as the first peoples of Australia is then the first proposed change to the Constitution. And I believe there are substantial implications that may flow out of that recognition, even if the text itself does not give us that impression. The second thing about the voice referendum is that it creates a new chapter in the Constitution. Having a separate chapter that recognizes Aboriginal and Torres Strait Islanders as the first peoples will most definitely have an impact on the nature and operation of the Constitution. Again, Remember here that there's no limit on using that new structure to interpret the Constitution. And currently we have 8 chapters in the Commonwealth of Australia Constitution, and the High Court has drawn implications from this structure. The first 3 chapters deal with the 3 branches of power. The Parliament in Chapter 1, the Executive in Chapter 2, and the Judiciary in Chapter 3. And the other chapters explain the dynamics of these government branches, either in terms of their finances, of their relationship to the principle of federalism, and in the last chapter, in relation to the process of constitutional change. And so, because of this particular structure, the High Court of Australia has recognized a separation of powers in Australia. It is a limited separation of federal judicial power, but a separation of powers nonetheless. Now, we have a video explaining the separation of powers in Australia, and you can click on the top right corner and watch that video. And we also have a video about how the High Court uses the constitutional structure to interpret the Constitution itself. So watch these videos. Also, why don't you take the moment to click the like button, subscribe to our channel, and hit the bell icon, because then you will be notified every time I upload a new video. And this is also the kind of video that I want to share, so that everyone around you, your friends and family, will be informed about the constitutional implications coming out of the Voice Referendum. Now, with the creation of the new chapter, there's also the possibility then of the High Court of Australia interpreting new things out of that new structure. I'm not saying that the Voice will have the same functions as the other branches. I don't think that's the case, and I think the wording in the proposal is very clear in that regard. But it may have a constitutional status comparable to the other branches. No other institution that is not the Parliament, the Executive, or the courts have such a constitutional status. No other institution has its own chapter in the Constitution. So again, I believe constitutional implications may be drawn out of this fact. Ultimately, the proposed new chapter makes of the Voice an indispensable and intrinsic part of the constitutional structure, and the High Court may interpret that the way it wants. Okay, I've given you some thoughts about the motive of the proposed constitutional change, and also some implications of acknowledging the Aboriginal and Torres Strait Islanders as the first peoples of Australia, especially via the creation of a new chapter in the Constitution. Now, let's look at section 129 and what it does. Section 129 says that in recognition of Aboriginal and Torres Strait Islander peoples as the first people of Australia, 1. There shall be a body to be called the Aboriginal and Torres Strait Islanders Voice. 2. The Aboriginal and Torres Strait Islander Voice may make representations to the Parliament and the Executive Government of the Commonwealth on matters relating to Aboriginal and Torres Strait Islanders peoples. And 3. The Parliament shall, subject to this Constitution, have power to make laws with respect to matters relating to the Aboriginal and Torres Strait Islander Voice, including its composition, functions, powers, and procedures. So the first thing that this section does is to establish a body to be called the Aboriginal and Torres Strait Islander Voice. The Voice is not created by the Constitution, but the Constitution gives the power for the Commonwealth Parliament to create it. But this is not only a grant of power. The language here is that there shall be a body. This is imperative. The Voice must exist. It is still possible, however, for this body not to be legislated. I am unaware of any constitutional remedy that would force Parliament to legislate to this respect. But, nonetheless, I believe the text compels Parliament to legislate this body. And the other thing is that the body is to be called Voice. It is in the singular. We are referring to a body called Voice. The one body has a name, and even if it is decentralized, structured in a federal-like manner or not, it must be only one voice. This has been the object of some contention because many Aboriginals do not believe this will give the necessary voices to all clans and mobs. But this goes maybe too much into the weeds. The thing here is that there shall be only one body, and this single body will be called the Voice. Subsection 2 of section 129 says that the voice may make representations to the Parliament and the executive government of the Commonwealth. A few things must be said here. First, the power is that it may make representations. This seems to imply that Parliament and the executive government do not have the duty to listen to the voice. There's a right to be consulted, but not a duty to consult. And even though there is a right to be consulted, I wonder whether the voice must give the representation. I do not think that it can be compelled to do so. It may make representations. The language here seems to imply that it may not be consulted, or even that it may not want to make the representations. The second aspect is what kind of representations we're dealing with. We do not know whether oral or unwritten representations will be allowed. Generally, representations are tabled before Parliament, and ultimately the idea is that representations will be publicized to a certain extent. So I don't really worry about the making of representations to Parliament itself. I think this practice already exists and is well established in political conventions even. But the representations to the executive government are the Gordian knot here. So the third aspect is the usage of the expression executive government. As you know, the executive government is composed of an array of institutions and persons. From the king to the public servant working in a small department of the Commonwealth, or even to those working in government-owned corporations and similarly autonomous agencies. Can the voice make oral representations to a public servant in an autonomous agency? Will they have the right to be consulted in decisions at this level of the executive government? This is the question that is bothering a lot of people. This seems to be a bit of a stretch, to be honest. And look, I don't mind anyone making representations to these public officials, etc. The issue here will rise if the right to be consulted becomes a duty to consult. Imagine having a right to make representation to the executive government as a whole. A right to be consulted before decisions of the executive are made, even seemingly minor decisions by small agencies and departments, well, that's too much. Even though the principle of responsible government says that the ministers sitting in Parliament will be ultimately responsible for the decisions of their respective departments, etc., the complexity of the chain of accountability would be too great here. And not to mention that we are cogging the wheels of a state apparatus that is already pretty bureaucratic. Honestly, I would much more like to see the representations being made to Parliament rather than having the voice also make representations to the executive government. In all honesty, I think this is a flaw in the proposed amendment, but I'm not naive to think that this is there by mistake. Finally, the second part of subsection 2 refers to making representations on matters relating to Aboriginal and Torres Strait Islander peoples. And this is also controversial, and I personally don't like this broad expression. I mean, look, I can appeal to my senses and say that some things relate to Aboriginal and Torres Strait Islanders and others do not. That's fine. But when I saw in the news about national defense, environment, education, health, all of these areas being submitted to the representation of the voice, it does not sound good to me. You may raise an argument saying that these areas do not belong to the Commonwealth, but if you've seen my video about the external affairs power and you saw how the implementation of international treaties can encompass all kinds of powers, including in areas that don't originally belong to the Commonwealth, then things start to make sense and you understand, I think, a bit more about my worry here. I do like the idea that people should always have a say on things that affect them. That's why I like democracy, that's why I like federalism. And I think it is important to have representatives in the Parliament, so that's great. But the extent to which these matters will overlap with all else that Parliament and the Executive do, it does seem a bit of an overreach, and in this sense, too much power being given to the voice. I think it would have been easier just to define the areas and say which areas would fall within the scope of the voice's representation. The framers separated different areas among the Commonwealth and the states. It defined the scope of the Interstate Commission of Section 101. I would find no issue in a proposal that would at least limit or exclude certain areas from the necessary advice of the voice. I think that should have been done, and I don't know why leave this general expression in the proposal. And this actually brings me to another point about the proposed constitutional body. Subsection 3 says that Parliament will, subject to the Constitution, make the law with respect to composition, functions, powers and procedures of the voice. In this respect, I hope, and I can only hope, that Parliament will also legislate with respect to the accountability mechanisms related to the voice. I mean, if this is an entrenched body in the Constitution, the voice must be responsible to someone. It cannot be an unrestrained body. We know from the separation of powers and from the dynamics of the three branches that there is a check and balances system in place in our Constitution. But who will limit the voice? To whom is it subjected? Since it has its own chapter, it does not seem to integrate the executive or Parliament or the courts for that matter. But will the mechanisms that already exist be able to control and hold the voice accountable? I sure hope so. Well, there are some other things, but I did try to dissect the proposal and present to you some potential constitutional implications of the voice. If this will lead you towards voting yes or no in the referendum, I can't say, but I hope you have seen the importance of this proposal and the importance of being educated about it. I do trust that you will make an informed decision, and all the best in the upcoming referendum on October 14. As for me, I hope to see you again soon. Ciao.